Commonwealth versus Donnie Kern. See if Mr. Kern is present.
Your Honor, Mr. Kern is not present any longer.
All right, well, Mr. Kern was present by telephone at the last hearing when this hearing was scheduled for today. It's been according to the file of the Commonwealth. On top of that, gave him notice of the hearing today. Mr. Kern has filed some pleadings indicating that he was aware of the hearing today. And apparently, Mr. Kern, at some point, he filed some items with the clerk at 8:30 this morning. So apparently, Mr. Kern was present in the courtroom and then has chosen not to stay. So, Mr. Jensen.
Judge, I'd ask if Mr. Guynn could proceed and start regarding the notice of removal that Mr. Kern has filed to have this matter moved to federal court.
Your Honor, this is a difficult spot for us, I actually had gotten late last night through the PACER electronic filing system in federal court a copy of the notice of removal. Was not sure if it had been filed this morning in the clerk's office, so having no communication from Mr. Kern came up to see because the rule is that this court is divested of jurisdiction when the notice of removal is filed in this court. So we were thinking maybe filed in federal court, not here. I do not think from an ethical and practical standpoint as attorneys that I can stand and ask the court to take any action today given my knowledge of the rule in that regard. I had hoped that Mr. Kern was going to be here because I was going to at least make a statement that I would still like to make, that I will include in a letter to him, and that is that the United States Code at 28 U.S.C. section 1446 governs removal and specifically says that Rule 11, which is the rule that requires pleadings to have a basis and not be frivolous, applies in those situations. And I would like for him to know that we will hold him strictly accountable to Rule 11. And we'll ask the court there, if he does not withdraw his request for removal, to apply sanctions, including attorney's fees for this hearing, as well as for the work we're going to have to do to keep the case remanded. I would also have said to him, if he were here, and we'll say in a letter to him, that the Virginia counterpart at 8.01-271.1 that requires that there be a good faith basis for pleadings also applies, and to the extent that he has both inconvenienced and vexed this court, clearly filing a notice of removal that has no basis. Frankly, it has to be done within 30 days of the suit being filed. There's no jurisdiction for federal court in this situation, and it is clearly a bad motive here with regard to either delay or some other sort of bad faith. And under those circumstances, again, we cannot in good faith ask the court to take any action today. However, we thought it was important to at least come in and make these statements on the record so that he cannot later say that he had no idea, because we want to give him a fair opportunity to do the right thing. But when he doesn't, we will then leave it to the courts to determine what the appropriate sanction will be.
All right, thank you. Jensen, anything you want to add?
No, Your Honor, I concur with Mr. Guynn that once this court received notice of the removal to federal court, it's divested of jurisdiction, and jurisdiction lies solely with the federal court until the matter is remanded, Judge.
All right, thank you, gentlemen. Then we will stay in these proceedings until we have an order from the federal court, which time I'm certainly happy to reschedule this motion, remand it here at the earliest convenience.
Thank you, Judge. I do have one administrative matter. I did bring Mr. Fishwick's order withdrawing from counsel. I don't know if the court has the authority to enter it now, if it can be done non-pro tunc, or if it can just be placed in the file until this court has jurisdiction again.
We'll just place it in the file and leave it to enter another day.
Thank you, Your Honor.
All right, thank you all very much. We'll be in recess.